Hey there, Texas Mopar, right? Everybody's waiting for Johnny Depp to go live, and then this comes out. Craziness, isn't it? We'll wait for some more people to get in here. I'm going to grab my coffee, and we'll go through this motion that was filed by the prosecution this time. So, let me get into here. Shocker, shocker. Alright, I'll be right there. I'm just going to grab my coffee, but we'll talk about this development. He's a free man right now. It doesn't mean that they can't file in the future. Okay, guys, hang on. I wonder if maybe it's a tactic to see if he'll go somewhere, to see if they can refile. So I wonder if it's a tactic. That's what I'm wondering. Maybe they figure with him not being confined, he might go back to where she might be, or might do something stupid, and they can refile. Who knows? But let's go through, pull up the, I have the, okay, here we go. Let me pull this over. Can't believe more people aren't all over this, but we'll see. So, the people of the state of Colorado versus Barry Lee Morphew motion to dismiss without prejudice. The people by and through Linda Stanley, District Attorney for the 11th Judicial District, hereby move this court to dismiss the charges against the defendant in 22 CR 47 without prejudice. This is the background, on May 6, 2021, the defendant was brought before the court on charges including the first-degree murder of his wife, Suzanne Morphew. To date, Ms. Morphew's remains have not been found. On September 17th of 2021, after the Honorable Judge, hold on a second, let me just, this thing, I just make sure this is not playing. Stop that, okay. The Honorable Judge Murphy found probable cause for charges listed in the indictment, but declined to find proof evident. Presumption great. The defendant was granted a bond that was quickly posted. The same day, the defense entered a formal plea of not guilty and agreed to toll speedy trial to accommodate a trial date slated to begin on May 3rd of 2022. In subsequent filings, the court added an extra few days of trial in anticipation of a more extensive jury selection period. Trial is now scheduled to begin April 28th, 2022. Throughout the pendency of this case, the people and the law enforcement have been unrelenting in our search for Ms. Morphew. For some time, a single location has been the target of ongoing investigation. For the reasons expressed below, the people have a good faith reason to believe further investigation into this matter is essential to answering the most consequential question presented by this case. As the search cannot be accomplished in the coming weeks due to weather and snowpack conditions, the people respectfully ask this court to dismiss the current indictment against the defendant without prejudice. Discretion to dismiss pending criminal actions. The prosecution has the constitutional power to exercise its discretion in deciding which of several possible outcomes to pursue in a criminal case. And then it gives you a case, People versus Lichtenstein, citing Myers versus District Court, specifically the decision to change a suspect consent to a deferred prosecution, or requesting dismissal are matters within the district attorney's sole discretion. The district attorney is part of the executive branch, and his discretion in requesting dismissal is governed by practical considerations. Again, Lichtenstein. At common law, the prosecution has the unilateral authority to dismiss criminal charges through the entity of nolo prosequi ID. Okay, the authority was limited by the enactment of Criminal P 48, which states, in relevant part, by the state, no criminal case pending in any court shall be dismissed, or no prosequi therein entered by any prosecuting attorney or his deputy, unless upon a motion in open court and with the court's consent and approval. Prosequi. Such a motion shall be supported or accompanied by a written statement concisely stating the reasons for the action. The statement shall be filed with the record of the particular case and be open to public inspection. Such dismissal may not be filed during the trial without the defendant's consent. Emphasis added. The statute parallels the federal rule Criminal P 48A. Okay, I'm just want to pull the chat back up so I can just see. So, wow, Captain Lee Fan, I can't believe that we don't have more people in here for this. This is crazy. Better they wait until they are sure. Exactly. Yeah, I think it just may be a tactic too, while they gather more evidence, and maybe they feel with him thinking he's a free man, he may implicate himself more, maybe lead them to a spot. I don't know. I don't think it's over for him. I don't think so. I don't think so. But, all right, we'll finish going through this. Hi, Mike. Yeah, wow, right? He's a free man right now, but that could change. They could refile. I think it might be a tactic. Hi, Danielle. So we're going through the motion. Hold on a minute. Hold on a minute. Clear my throat. Okay. So we're going through the motion to dismiss without prejudice that was filed by the prosecution. It means he left the courthouse a free man, but they could refile. They said there is a location they're searching. Weather and other issues are making it impossible to do that now, and with the trial slated to start on April 28th. Right, exactly, Danielle. And I think that this may be a tactic that they're using to see it when he's out, if he leads them to something. Hang on 1 minute. Okay, so yes, wait, don't take a chance, because exactly. So, excuse me. I think that this is going to, really, the charges will be filed again. I think that they're just waiting for him to do something or lead them to something, or for him just to act stupid and pompous and fun. You know what I mean? I just think it's their tactic because they don't want to take a chance at him, being found not guilty by a jury. So let's finish reading this. The prosecution is intended to give the court some supervisory power over the prosecution for cases to the extent the interests of justice as well as the interests of the defendant and society are implicated. Again, Lichtenstein case they're citing. Thus, in exercising its discretion in reviewing a motion to dismiss charges, the trial court should not serve merely as a rubber stamp for the prosecution's decision. Ultimately, while a court has discretion to deny a motion to dismiss, the circumstances are narrow, as the principles behind the separation of powers gives the people the sole power to prosecute crimes. The decision to request dismissal of pending criminal charges is within the district attorney's discretion, and this decision may not be controlled or limited by judicial intervention. The trial court, however, should not arbitrarily substitute its own decision for that of the prosecution. Rather, the court must exercise judicial restraint and only act if the dismissal is clearly contrary to public interest. A trial court's refusal to consent to dismissal of charges is only appropriate where the evidence is clear and convincing that the interest of the defendant or the public are jeopardized by the refusal to prosecute. Emphasis added. Leave to dismiss will be granted if the government is without sufficient evidence to obtain a conviction or if dismissal is sought for some other bona fide reason that does not involve harassment of the defendant. And then it quotes Right Federal Practice and Procedure. In evaluating this standard, the court must look to the reasoning behind the dismissal and whether or not the decision to dismiss is made in good faith. The court in Starley later clarified that the prosecution is presumed to have acted in the best interest of the public unless it is shown that it acted in a manner inconsistent with good faith, People v. Starley, holding the trial court abused in its discretion in denying a motion to dismiss without evidence of prosecutorial bad faith. Examples of bad faith were adopted by Starley court to include the prosecutor's acceptance of a bribe, personal dislike of the victim, and dissatisfaction with the jury impaneled. If it should appear that the prosecutor is motivated to dismiss because he has accepted a bribe or because he desires to attend a social event instead of attend upon the court in the trial of the case, or because he personally dislikes the victim of the crime, the court should withhold leave. Another example of bad faith would be, as was noted in Lichtenstein, the harassment of the defendant, Starley, and it lists a bunch of pages. A trial court's denial of a motion to dismiss is reviewed under an abuse of discretion standard, Lichtenstein. The exercise in discretion to dismiss cases has been tested in many Colorado cases over the years. In Lichtenstein, the Supreme Court of Colorado considered whether a trial court abused its discretion by denying a motion to dismiss by the prosecution for a single severed count against a defendant, leaving the remaining count eligible for a jury rather than a court trial. So what they're saying here is they're just going over that, of course, it should never be decided, though the prosecution, the district attorney has the power to dismiss this action, it should never be accepted if it's in bad faith, meaning that it's done because the prosecutor accepted a bribe or because he personally doesn't like the victim, in this case Suzanne, or they're harassing the defendant. So that they're just going through some things that should never be. It's just that really matter of just stating all the P's and Q's there. The exercise of discretion to dismiss, where were we? Trial courts abuse discretion in this every case, leaving the rather than a court trial. Specifically, the court held, in this case, the dismissal of the lesser charge was a decision made by the prosecution to maintain its right to require a jury trial on the issue of sanity for more serious of the two counts. The prosecution was attempting to obviate any potential conflict between two inconsistent statutory rights and protect the people's interest in a jury trial on the issue of sanity for the Class 3 felony in accordance with the legislative intent of Section 16.8.105.2. At 73, the court held that the trial court abused its discretion because the prosecution's decision to dismiss the lesser count was as a good faith exercise in prosecutorial discretion. Similarly, the court in Starley was asked to review a trial court's denial of a motion to dismiss charges of sexual assault on a child by the prosecution. Starley, okay, and it lists the pages there. The prosecution pointed to concerns that they had with the victim's memory, the credibility issues. They're going just through right here, just through this other case, this Starley case, as it relates to this motion that they're filing to dismiss without prejudice. Okay, so while the prosecution initially stated the victim did not object to the dismissal, a subsequent letter to the court authored by the victim revealed the opposite. The trial court, upon hearing the victim's objection, denied the prosecution's motion to dismiss. So that's where the defendant didn't want to dismiss this. And then the defendant wrote a letter in this case, and then the judge denied the motion to dismiss. Colorado Supreme Court made factual findings that the prosecution in this case based its motion to dismiss the charges against Storley on its candid assessment of the strength of the victim's and potential witnesses' testimony. The determination is the quintessential example of a good faith exercise of prosecutorial discretion. Further, the court could not find any basis for concluding that the prosecution acted in bad faith. The trial court argued that it properly exercised discretion by acting consistently with the victim's wishes and broader societal concerns. But these arguments were not relevant to the ultimate determination at hand. The court held that the discretion to dismiss lies with the prosecution, not the trial court. Therefore, the question is not whether there might be good reasons to deny the prosecution's motion to dismiss, as respondents suggest. Rather, the question is whether the prosecution sought to dismiss the charges based on a good faith exercise of its discretion. Accordingly, the court found that the trial court abused its discretion in denying the prosecution's motion to dismiss the case in its entirety. The effect of dismissal without prejudice. A dismissal has varied effects with regard to the final disposition of a case. In some instances, a dismissal will preclude further prosecution, and in others it will not. Okay, so what they're going to tell you here is the difference between a dismissal with prejudice and without prejudice. A dismissal without prejudice, as this one is, okay, is a formal declaration of record by the prosecutor that the government will not prosecute the current case further. It is a discharge without an acquittal and is not a bar to a subsequent prosecution for the same crimes. So what that means is he can be prosecuted for this same thing, the murder of his wife, at a later time. It doesn't say he was not acquitted. Okay, so he was not acquitted. It's a dismissal without prejudice, but leaves the matter in the same condition as before the charges were filed. So basically, what he is walking around as before the arrest, that at any time, should they find anything, they can arrest him and charge him again. So he's a free man, but not a free man. A free man as he was prior to being arrested. Okay? At any time it can change. This is not an acquittal. Thus, the indictment against the defendant would function as a nullity upon its dismissal without prejudice. Colorado rules mirror the federal rules on this subject. A dismissal properly taken under Federal Rule 48A is without prejudice, and within the period of the statute of limitations, a second indictment or information may be brought on the same charge. In fact, federal case law recognizes that there is a presumption in favor of dismissal without prejudice over a dismissal with prejudice. The mere fact that a dismissal without prejudice leaves the door open to hypothetical future prosecution in this jurisdiction is not tantamount to prosecutorial harassment. Were that the case, it is difficult to imagine when dismissal without prejudice would ever be appropriate. In small, the Colorado Supreme Court dealt with this issue of a case being refiled under dismissal of charges without prejudice. Couched with a constitutional speedy trial argument, the court assessed the reason for the delay in the prosecution. The court made factual findings that the dismissal of charges was here sought to allow further investigation of the underlying crime and to avoid putting the defendant in criminal jeopardy on evidence of uncertain credibility. In other words, in keeping with the prosecutor's duty to seek justice. Okay, and then a prosecutor has the discretion to seek the dismissal of charges pending further investigation of a case, even if the defendant may be somewhat prejudiced as a result. The court in the Arnold versus McCarthy, the court further held where delay is the product of valid investigative or prosecutorial purpose, it is not chargeable against the government, even after identical charges were refiled against the defendant based on new investigation, relevant speedy trial principles were not violated. Okay. So at any time again, they can charge him. So it's like this black cloud always over his head, especially as many of us feel that he is guilty of this. Then hang on one second. Sorry about that. I had to answer. That was my son. He's calling it Italy, and I had to give him a name. Okay. So where were we? Good faith basis to dismiss. As an offer of proof, the people and law enforcement believe we are close to discovering the victim's body. So this is what they're saying, okay? They're close to discovering Suzanne's body. They said they have a location that they're targeted on, but the weather and other issues are preventing that. And with his trial due to start on April 28th, they're going to dismiss this rather than him being found not guilty, and that's it. They can't prosecute him again. So they'd rather let him go now, but they're going to be refiling. I can tell you that. And this is like a small victory for him because there's a black cloud over his head, right? And what if he tries to cover up something and implicates himself? It may be it's a tactic because they don't want to lose the case. And maybe in the process, he will even give them some more information, what they need. Yes, Aurora, it was dismissed by the prosecution. Right now, he's a free man, but it was dismissed without prejudice, which means they can refile the charges at any time. Okay? So, let's go back and read this now. So they say that they are close to discovering the victim's body. The people were hopeful that the search for and the discovery of the victim's body would be concluded well before trial, but weather has complicated the efforts. Specifically, the area law enforcement has been focused on is in a remote and mountainous region nearby the Morphew residence. So they believe that Suzanne's body is in a mountainous region nearby the Morphew residence. The residence that has now been sold and other people live there, but they believe that it's there, right? Hi, everybody. Hi, Storage Bandits. Hi, Jennifer, Mike, Annie B. Laura. The area received a significant amount of snow over the winter months before a search could be completed. To date, the area has 5 feet of snow concealing the location where the people believe Ms. Morphew is located. As a result, the people cannot safely excavate the area and resolve this unanswered question. So it's all over for Barry. Again, the charge will be filed with the spring thaw, they excavate, and they find the body, right? So he's a free man, but again, that black cloud, because if he did this, and a lot of us strongly believe that he did, then what's going to happen is it's going to be refiled and he's going to be right back where he is. By filing this motion, the people have complied with Rule 48A, a motion to dismiss, submitted in writing, publicly available, proffered in open court, and accompanied by a statement summarizing the reasons for the action. Given the timing of this motion before trial, the defense does not need to consent and does not have standing to object. So the defense has no say in it. The court need only resolve the question of whether or not this motion was filed in good faith, such that clear and convincing reasons exist which further the interest of justice for the public and the defendant. Issues related to speedy trial or any other outstanding litigation would not be relevant to the court's determination at this juncture. Here the people have presented sufficiently reliable good faith reasons to dismiss without prejudice. First, the people believe that we are close to locating the deceased victim's body. They believe they are close to finding where Suzanne has been buried. The people's fundamental responsibility in the criminal justice system is not to gain a conviction, but to further the truth-seeking process and ensure equal justice. In typical homicide cases, the fact of the victim's death is rarely at issue. But in a case such as this, the most influential fact of consequence is whether or not Ms. Morphew is deceased. If the body proves to be there, further forensic examination could potentially inculpate or exculpate the defendant, which is incredibly important evidence for the jury to hear in determining the merits of this case. Remember, Patrick Frazee said, no body, no crime. Okay, so what they're saying is it is very difficult to prosecute a case without a body when some people are questioning whether she's even deceased. So if they could find the body, that would be paramount. And if they could find evidence on the body that links it to the defendant, even better in prosecuting the case, in other words. Given the need to conduct further investigation to resolve these issues, this is a good faith basis to dismiss the current indictment. Second, when this case was filed, it was mainly premised on the defendant's motive to harm the victim. His sole access to the victim at the exact time she was last communicating with anyone by phone, and his consistent dishonesty with law enforcement, which came to light given the truck telematics, phone, and location data recovered, the court functionally excluded the people's best evidence to move forward in this case by severely limiting our expert's testimony. Even if the court were to partially reconsider its position on the need for such severe sanctions as this late hour, the people would still be left without several key expert witnesses initially endorsed. Without this crucial evidence and without the victim's body, the people cannot move forward at this time in good faith. Ethics demand that prosecutors proceed to trial only in circumstances where a reasonable likelihood of success exists, which gives the court's current rulings and the uncertainty of any further rulings is impossible to completely ascertain. This assessment of the remaining evidence is an additional good faith basis for the motion to dismiss without prejudice. Just hang on one second. I just want to hold on real quick. Okay. Just had to do something. The interest of the public and the defendant are furthered by dismissal. The ongoing investigation into the location of the body must be resolved to further the interests of the public. The public seeks a swift resolution of this case, but more than anything, seeks an indisputable answer as to whether or not Ms. Morphew is dead before the killer can be held accountable. So, what they want to do is find her body. They really do believe they know the area she's in. They need more time. They wouldn't be able to do it before the trial is slated to start on April 28th. And they're not willing to take that, chance there. So they're dismissing it without your son, without prejudice, in order to be able to bring the charges again. They can file the charges again. So this isn't the end of this case. I don't believe it is. If they truly do believe they know where the body is, well, as soon as they're able to excavate and exhume it, then they would file the charges again, and it may even give them more evidence against Barry Morphew. Oh, yes, absolutely, Millie. That's what I just said. Yeah. It's not, it's not the end. He's a free man for now, but he's a free man much in the way he was before he was arrested to begin with. Okay? Where every day could be the game changer. He's not a free man that he's been acquitted. He has not been acquitted of the murder. So there's a big, big difference there. So if there was no activity on Suzanne's phone from 4:30 a.m., Barry said she was asleep when he left after 5, and the phone hasn't been found yet. Surely this alone tells us. Yeah, but they need more than that, you see. They can always argue without a body. It's very difficult to prosecute, right? So they want to find that body. Okay, so let's see. The motion also protects the defendant, as it spares him from a jury's fast approaching and potentially unfavorable verdict. The defendant's bond would be discharged and the case would be a nullity. In the event the case is refiled, the defendant retains all of his rights to further litigation and perhaps collateral estoppel on issues already decided. As such, the defendant's position would be no worse and perhaps even stronger should the case ever be refiled. The case law clearly articulates examples of bad faith, including bribery, not liking the victim, or disagreeing with a juror panel selected before trial, none of which are present here. So they're saying they're not doing any of this in bad faith. The dismissal does not serve to harass the defendant in any way. Courts have consistently found that even refiling a case several times over is not enough to constitute harassment. So they're not dismissing this to refile it, to dismiss it, to refile it in order to harass him. Okay, so it's not that's what the harassment would be. And the mere act of dismissal is not enough to carry this burden. The procedure of dismissing without prejudice has been accepted in common law and statute for decades. More, it is a preferred means of proceeding when outstanding evidentiary questions exist. The dismissal places the case in a pre-filing posture and is no more harassing of the defendant than the circumstances before May of 2021. So it's just as he was prior to that May 2021 arrest and charging of murder, charges of murder put on him. He's just like that. The people spoke with Melinda Mormon Baumunk, the victim's sister and primary representative for the Mormon family. Ms. Mormon Baumunk relayed her agreement with the motion to dismiss and expressed her wishes that we ultimately resolve absolutely whether or not her sister is dead prior to further prosecution. So those of you that said you felt sorry for the family has agreed to this. The family spokesperson, Melinda, which is Suzanne's sister, said they want this to be prosecuted when they find whether or not her sister is dead. So they don't want this prosecuted before they know that for a fact, which would mean finding her body or finding her alive, right? The people also spoke with Andrew and David Mormon, the victim's brothers, Suzanne's brothers, and they are also in agreement with this motion. For obvious reasons, the people have not endeavored to speak with Macy or Mallory Morphew, but would be happy to hear their position in court. Those are Suzanne's daughters, okay? Macy and Mallory. They didn't speak with them for obvious reasons. As such, given the ongoing investigation, the state of evidence, and the position of the victims, the people asked this court to dismiss this case. The case at this time, the dismissal is in the best interest of justice, the people, and defendant, and the public. Respectfully submitted, Linda Stanley, District Attorney, and then it shows that it's going to the other attorneys there. Okay, and let's see here. So that's the motion, and yeah, the family is in a total agreement with that. Doesn't mean that it's not going to be refiled, you know. But that's what we have. So I don't think any of us were expecting that today. We're waiting for Johnny Depp to take the stand. And I don't even know if he has while I've been on. I know they broke for lunch. 1 second. Okay, so yeah, you know, I don't know. This is not what we expected, right? I don't think, I mean, it's got to feel like, yeah, I mean, you're free for now, but they're just waiting to excavate an area or waiting for you to slip up and try to cover something up while you're out that's going to implicate you more. So I don't know how, you know, how great that is for him. Johnny Depp's now testifying live. That's probably why we have so few people in here, because he's testifying. So I will bring us back to that. I'm going to go watch that myself. And just, yeah, surprise turn, you know, that he is a free man for now, but without prejudice. It can be brought, he can be brought up on charges at any time. Anytime. And the family is in agreement with the prosecutor who filed this, Linda Stanley. And, all right, actually, I think this is good. And just put him through the pain over the past. Yeah. Okay, I am going to go watch. I figured something was going on. I figured that he must be on. All right, we'll talk about this later. Let's go watch Johnny Depp. All right, everybody take care. Bye-bye now.